The other big story tonight on India Business Hour, the Cabinet has approved India's first policy on intellectual property rights. However, we have stood firm on the issue of compulsory licenses and evergreening of drug patents. But the devil is always in the details. So let me take you through the key highlights. There will be no change in India's stance on compulsory licenses issued to pharma companies. That is what the government has said. The government says it will continue to have the power to allow someone else to manufacture a patented product. Finance Minister Arun Jaitley reiterating that the compulsory license regime is compliant with the World Trade Organization's norms, and India has issued just over one compulsory license so far. However, the fine print does indicate that legislative changes will be carried out from time to time. So does this mean that the centre is leaving the window open, even though it's not amending the IPR law at the moment? Number two, there is no change in the government stance on evergreening. Now remember, evergreening is a process by which pharma companies make small changes to a drug which is set to lose its patent, thereby extending its patentability. In a landmark verdict, the Supreme Court has rejected global drug major Novartis' patent to its cancer drug Glivec in 2013. So no dilution in the government stance on evergreening. And finally, the policy is aimed at improving the ease of doing business. So companies can now register their trademark in just a month, but that's starting 2017. Also, the Department of Industrial Policy and Promotion will be the nodal authority and not the human resource development body. But that's only as far as copyright laws are concerned. Unveiling the policy, the Finance Minister asserting that life-saving drugs will remain cheap and that there is no plan to amend the IPR laws at the moment.
We believe that our patent laws, our intellectual property laws are WTO compliant. So there is no proposal to immediately amend any of these laws. The whole administration, awareness, enforceability of IPR is to be made effective. For instance, you have a compulsory licensing provision today in relation to musical works in the Copyright Act. You have a provision of the compulsory licensing in relation to the Patent Act as far as in public health emergencies are concerned. So these are all, both are WTO compliant, and they will continue.
Well, that's the Finance Minister taking us through the IPR policy that's been cleared by Cabinet. To discuss the implications, we're joined now by Keval Handa, the former Managing Director of Pfizer. Also with us, Rajeshwari Hariharan, a lawyer looking at IPR issues. She was NATCO's lawyer in the compulsory licensing case. And A. Vedish, Vice President South Asia and Managing Director of GSK Pharma. Gentlemen, appreciate you joining us here on the show, and Rajeshwari, appreciate you joining us on the show. Mr. Handa, let me start by asking you, there's been a lot of talk about a possible convergence between India and the US, especially on the issue of IPR, on the issue of pharma patent-related issues. But if you go by what the government is saying, that our provisions of compulsory licensing and, more importantly, that controversial 3D provision of evergreening, India has stood by its stance and it hasn't given in. At least that's what it seems to be at this point in time. How do you propose this is going to go down with the US and European administrations as well as MNC pharma companies?
As a precursor, the USTR has already put India and China on a priority watch list. So they are really started taking some positions there. So this reiteration by the government that the 3D won't change, the compulsory licensing provision won't change, perhaps may not go well with the US government and some of the US-based pharma companies. Maybe you will see a lot of these things happening when you do the individual treaties with these government and some of the European countries also. So there is a mixed feeling here amongst the US companies also. Some of them have adjusted to this patent life in India and have adjusted to the pricing environment and started doing business accordingly. Some of them are still struggling with it.
Okay, Mr. Vedish, let me put that question to you. Have you adjusted with the environment in India? And really, are the concerns exaggerated? I mean, the USTR, this is not the first year that we've been put on the watch list. We were on the watch list last year as well. But let's just look at the facts. India has so far only issued one compulsory license. We have been, as per the government's claim, TRIPS compliant, and the government has reiterated that claim this time around as well. What is your contention?
The first and foremost, we need to recognize this IPR policy, frankly, in my opinion, is a well-articulated policy. And the fact that government is saying that this recognition of IPR as a marketable financial asset and economic tool, it's well articulated there. If that is the case, I guess they would know that, the term like evergreening and, these are all something which can be discussed. But fundamentally, there is a big shift the government has done in this IPR policy, which in my opinion, I would welcome the kind of detail in which this IPR policy has done. There's a clear articulation of policies, and there it talks about how do I create awareness, how do I stimulate the generation of IPR.
Yeah.
This is a very good sign. I don't see negativity in this IPR policy at all.
Okay, that's good to hear. Rajeshwari, let me ask you this question, because the government has stated in its IPR policy that it could review the law in future on a case-by-case or a need basis with the view of improving upon the law or removing certain anomalies. In that context, do you believe that the window is open for the government to perhaps review its position on something like a CL or something like 3D, which of the Patents Act, which says evergreening will not be allowed unless there is therapeutic efficacy?
Yeah, so I see. So in my view, the Indian law which we currently have is very well balanced. So it allows companies to enforce their rights. It also allows Indian companies to make their own innovations because of 3D, etc. So, and we also have a provision of compulsory license. So on a case-to-case basis, it should be assessed, and that is how I believe the government is taking it. For example, in the NATCO case, it was a well-deserved case, and the compulsory license was granted. In some other cases, the government has, the patent office has rejected it. So I think the compulsory license issue is being examined on a case-to-case basis, and which is how it should be done everywhere, and this is how it is being done in India as well. So maybe in the future, maybe the government might want to consider issues like permitting new use, because there are a number of innovations which are made in India, which are actually new uses of substances which are already existing, and therefore the government might want to consider in the future to promote and to foster innovation, to consider granting patents for new use. But otherwise, today we have a very balanced system in patent law, where you're able to enforce your rights. I think many companies have been able to enforce their rights, including Novartis and the Pfizer and the whole bunch of these companies. And I think even the Indian companies have had a fair share. So I don't think we should have a system, even as of today, to complain against the system. It's the working of the system. It is how we contribute to it and how we interpret it.
Sure. Yeah. Let me go back again and get in a view from GSK. The government is talking about reviewing the law with the possibility of improving upon it or removing certain inconsistencies and anomalies. As things stand today, as Rajeshwari was pointing out, she believes it's fair. But what are the changes that you would like to see, perhaps, which aligns India's law with global standards?
Well, if you look at the policy per se that has been articulated here, frankly, it covers most of the points that one would expect to have. I think the issue is in the way in which it's going to be implemented. But I must also tell you that there is an articulation of the execution piece, the implementation guidelines, and there is a big attempt that has been made to improve the administration and management and creating an awareness. I somehow believe that I think there is a genuine attempt has been made in the policy to figure out how do we implement what has been articulated. It's a TRIPS compliant, right? So India is clearly saying we are TRIPS compliant, and there are some public interest, and they're also recognizing the rights of the owners of the IP. I think whatever need to be said, that has been said in this. The issue is going to come only when it comes down to adjudication, and and that also has been addressed by saying that they are going to tighten or improve the adjudication process. So I see that as a very authentic and genuine approach to our IPR policy. Now, what we need to see that how it's going to get executed.
Well, that's what the policy document does talk about, of speeding up timelines and ensuring that the patent grant process itself becomes more efficient. Rajeshwari, I want to talk to you about how this policy stacks up beyond pharmaceuticals and beyond healthcare. We are in an environment where startups, have been mushrooming, and that's the real buzzword now in India. So beyond pharmaceuticals and healthcare, if you're talking about R&D in other areas like IT, like startups, then the current regime that's been ushered in today, is it adequate to foster that R&D environment and really, meet the objectives of creative India and innovative India, which is the latest slogan that now we've heard from the government?
Yeah, sure. The policy is nothing but a roadmap of what we want to see in the future, perhaps the next 5 years, the next 10 years, and 20 years, maybe 10 years. And the policy clearly lays down that they will bring in about a regime for utility models. So utility models is something which is available as a right in Germany, in France, in UK, in Japan, and other countries. And utility model helps to protect certain innovations, which are really incremental, small innovations. And at the moment, when we are talking about startup companies, these are the kind of rights that we want to give them. And we also want to give them expeditious rights. So that's how the rules are coming in as of today. Today we have the patent rules which will come into force from Monday. And these rules will grant patent rights very quickly. They will also grant trademark rights also very quickly. So therefore, it is these kind of changes which are absolutely in line with the policy that are being taken by the government, which steps are the ones which are going to foster innovation, which is going to help the startup companies. Ultimately, what does a startup company want? They want its technology, that its little platform to be properly protected. So with these kind of rules and with these kind of tight mechanisms, I think we should be able to, achieve the slogan of Stand Up India, Startup India, Stand Up India.
Well, we now deal with a new slogan, Creative India, Innovate India. That's courtesy the IPR policy that's been cleared by Cabinet today. And of course, Rajeshwari, thanks very much for articulating for us the use of utility patents. And of course, the government is also now said
Shireen, I just want to add one thing.
Yeah, go ahead, Mr. Handav.
I think the one thing that we are missing here is we have not seen anything on data exclusivity. If you really want to encourage and foster innovation, and therefore you want to give some period of exclusivity for the person who generates this data, it's not as per the global compliance. China has a data exclusivity of 5 years. And I think that's where the first movement we should make is to provide a data exclusivity. And that will foster R&D and innovation in this country.
Okay, I'm not sure if the fine print has anything on that, but 28 pages, that's the IPR policy for you, including the fact that the DIPP is now going to be the nodal ministry to deal with copyright laws and trademark registration from 2017. The time period will be truncated to about a month. Rajeshwari, Mr. Vaidesh and Keval Handa, appreciate you joining us here on CNBC TV 18 with your take on the new IPR policy. But